Maybe if you spent less time worrying about paperwork and more time learning to speak proper English, you'd understand what I'm actually asking for. That's what Derek Hamilton, our VP of Engineering, said during a team meeting on a Thursday afternoon in April 2023, making a show of his frustration with my accent while the rest of the engineering management team sat in uncomfortable silence. Proper English. I'd been Immigration Compliance Manager at Novatech Systems for 6 years, managing H-1B visa sponsorships and immigration documentation for our technology workforce of 273 employees from 41 countries, ensuring every visa petition was properly filed and every regulatory requirement was met so that our engineers could legally work in the United States and the company avoided the kind of compliance violations that could result in audits, fines, and inability to sponsor future workers. But according to Derek, our VP who'd been promoted 8 months earlier despite having no experience with immigration law or international workforce management, my Indian accent was a communication problem that interfered with his ability to get quick answers to visa questions, and he'd decided that mocking my speech patterns in front of my colleagues was an appropriate way to express his impatience with immigration processes he didn't understand. I'm Priya Sharma, and I sat in that conference room at Novatech Systems watching Derek dismiss my explanation about H-1B annual cap limitations while making jokes about my pronunciation. And I knew exactly which immigration regulations Novatech was violating under his leadership and exactly what would happen when USCIS auditors eventually showed up to review a company that had been cutting compliance corners to speed up hiring timelines. 6 years, 4 months, and 11 days of ensuring Novatech maintained proper immigration compliance, building systems that protected both our international employees and the company's ability to sponsor visas. And Derek had decided that immigration law was bureaucratic paperwork that moved too slowly and that my accent was a convenient scapegoat for his frustration with regulatory processes he found inconvenient. I wasn't the executive who made hiring decisions or the recruiter who sourced engineering talent. I drove a 2018 Toyota Corolla with 91,000 miles on it and stacks of immigration law updates in my passenger seat because I reviewed USCIS policy changes during my morning commute when other people listened to music. I lived in an apartment in San Jose with a home office containing filing cabinets full of visa petition files, labor condition applications, and immigration compliance documentation that I'd organized meticulously because managing immigration sponsorships requires understanding the complex federal regulations that govern employment-based visas. My bookshelf contained immigration law textbooks, USCIS policy manuals, and case files from immigration audits at other tech companies that I'd studied to understand what happens when companies take shortcuts with visa compliance. I was detail-oriented, methodical about regulatory requirements, protective of our employees' immigration status, and apparently creating frustration for a VP who thought visa approvals should happen instantly and who believed my accent was interfering with his ability to understand immigration law rather than his own lack of knowledge about how the system actually worked. The trouble had started 8 months earlier when Novatech Systems had promoted Derek Hamilton to VP of Engineering to accelerate product development and scale the engineering organization. Novatech developed cybersecurity software and our engineering team was critical to product innovation. Like most Silicon Valley tech companies, Novatech relied heavily on international talent. Approximately 65% of our engineering workforce held H-1B visas or were permanent residents who'd been sponsored through the green card process. Derek came from a large enterprise tech company where he'd managed domestic engineering teams without significant involvement in immigration matters. He had that aggressive growth mindset, talking about moving fast, removing blockers, and not letting bureaucracy slow down hiring, that works well when you're hiring U.S. citizens but becomes dangerous when you're managing a workforce dependent on immigration compliance. Derek's first conflict with immigration process had happened in October 2022, 2 months after his promotion, when he wanted to hire a talented engineer from India who'd interviewed exceptionally well. The engineer was currently on an H-1B visa with another company and would need to transfer the visa to Novatech. Derek wanted to bring the engineer on board within 2 weeks. I'd explained that H-1B transfers typically take 3 to 4 months due to USCIS processing times, and that we couldn't legally employ the engineer until the transfer petition was approved. Derek's response had been frustrated. Why does it take 4 months to transfer paperwork from one company to another? This is just bureaucratic inefficiency. Can't we expedite it or find a way to bring him on board while the transfer is processing? I'd explained that USCIS had specific processing timelines, that premium processing could reduce the timeline to 15 business days for an additional fee, but that we absolutely could not employ someone before their H-1B transfer was approved. Doing so would be unlawful employment that could jeopardize both the employee's immigration status and Novatech's ability to sponsor future visas. Derek had characterized this as immigration red tape that was preventing him from building his team quickly. Over the next 6 months, Derek had consistently pushed back against immigration timelines and requirements. In December 2022, he'd questioned why we needed to file labor condition applications for H-1B positions, viewing them as unnecessary paperwork. I'd explained that LCAs are federally mandated documents that attest to wage levels and working conditions, and that filing fraudulent or incomplete LCAs could result in fines up to $10,000 per violation plus debarment from the H-1B program. In February 2023, Derek had tried to pressure me to file H-1B petitions with inflated job descriptions to increase approval chances. I'd refused, explaining that petition fraud was a serious violation that could result in criminal charges. Derek had accused me of being overly cautious and not understanding the competitive pressure to attract talent. By April 2023, Derek's frustration with immigration processes had evolved into personal attacks on my communication style. During the April meeting where he'd made the proper English comment, I'd been explaining why we couldn't immediately hire 3 engineers who were graduating from U.S. universities. They'd need to go through the H-1B lottery process, and only about 25% of lottery applicants received visa approvals due to the annual cap of 85,000 visas. Derek had interrupted. "Priya, I'm asking you a simple question. Can we hire these 3 engineers or not? I don't need a lecture about lottery systems and cap numbers. I need a yes or no answer. Maybe if you spent less time worrying about paperwork and more time learning to speak proper English, you'd understand what I'm actually asking for." The room had gone silent. Several managers looked uncomfortable. I'd responded calmly, "Derek, I understand your question perfectly. The answer is that we can make job offers to these candidates, but whether they can legally start work depends on whether their names are selected in the H-1B lottery, which happens in March each year. If they're not selected, they cannot work for us unless they have alternate work authorization. This isn't about my communication. This is about federal immigration law that doesn't care how quickly you want to hire people." Derek had dismissed my explanation. "Just figure out how to make it work. That's what I'm paying you for." The meeting had ended with Derek making it clear he expected me to find ways around immigration timelines rather than explaining why regulations existed. Now about 74% of you think I'm about to report Derek to HR for discrimination or file a complaint about his comments, and you're wrong. Subscribe right now, because what actually happens is that a VP who doesn't understand immigration compliance creates violations through his own decisions, and federal agencies enforce immigration law without caring about his frustration or his opinions about my accent. After the April meeting where Derek mocked my accent, I documented the incident in an email to myself with the date, time, attendees, and exact comments. I also sent a carefully worded follow-up email to Derek summarizing the H-1B lottery constraints we discussed and noting that Novatech could not legally employ H-1B workers whose petitions weren't approved, regardless of business urgency. Over the next 3 months, Derek continued pushing to expedite hiring in ways that violated immigration regulations. In May 2023, Derek wanted to hire a software architect from China who was finishing a PhD program. The candidate's student visa would expire in June, and Derek wanted her to start work immediately. I explained that she would need either an H-1B visa or optional practical training work authorization to begin employment legally. Derek asked whether we could just bring her on as a contractor rather than an employee to work around the visa issues. I explained that contractor designation doesn't eliminate immigration work authorization requirements. She still needed legal work authorization regardless of how we structured the relationship. Derek responded that I was finding problems instead of solutions, and that other companies managed to hire international talent without these delays. What Derek didn't understand, and what he refused to learn despite my repeated explanations, was that immigration law is federal law enforced by agencies with significant investigative and penalty authority. Companies that violate immigration regulations face consequences that can't be negotiated away by aggressive executives. In June 2023, Derek made a decision that would ultimately trigger a compliance crisis. He wanted to hire an engineer named Raj Patel who was currently on an H-1B visa with a competing tech company. Raj had interviewed well and Derek wanted him on the team immediately. I explained the H-1B transfer process. We'd file a transfer petition with USCIS, pay for premium processing to get a decision within 15 business days, and Raj could potentially start work once the petition was filed. There's a legal concept called portability that allows H-1B workers to change employers once the new petition is filed, before it's approved. Derek asked whether we could skip the petition filing and just have Raj start work immediately since he already had an H-1B visa. I explained clearly, Derek, Raj's current H-1B is tied to his current employer. He cannot work for Novatech until we file an H-1B transfer petition. If he starts work before we file, that's unlawful employment that violates immigration law. Once we file the petition, he can start work under the portability provision while we wait for USCIS approval. But we absolutely must file the petition before his first day. Derek had responded, fine, file whatever paperwork you need to file. But I need Raj starting next Monday. Make it happen. It was Thursday. Filing an H-1B transfer petition required preparing the petition documents, obtaining a labor condition application, and submitting everything to USCIS. The LCA itself required posting at the worksite for 10 business days before filing, which meant we couldn't possibly file the petition before Monday even if we started the process immediately. I explained this timeline to Derek. Derek's response, Priya, I don't have time for your bureaucratic excuses. Figure it out. Raj is starting Monday. I sent Derek an email on June 15 explicitly stating, to be clear, if Raj Patel begins work at Novatech on Monday, June 19 without an H-1B transfer petition having been filed with USCIS, Novatech will be employing him unlawfully in violation of immigration regulations. I cannot expedite the LCA posting requirement as it's federally mandated. I strongly recommend postponing Raj's start date until we can properly file the transfer petition. Derek responded, Raj starts Monday. Handle the paperwork afterwards. On Monday, June 19, Raj Patel started work at Novatech. I had not filed his H-1B transfer petition because the LCA posting period hadn't been completed. Raj was working unlawfully. Novatech was violating immigration law. And Derek had explicitly ordered this violation over my written objection. I documented everything. I sent myself detailed emails with dates and Derek's exact instructions. I continued processing the H-1B transfer petition as quickly as possible, completing the LCA posting period and filing the petition on June 29, 10 days after Raj had started work. But those 10 days of unlawful employment were a violation that couldn't be undone. In July 2023, Derek created a second violation. He wanted to hire an engineer named Li Wei who was on a student visa completing a master's degree. Li's program ended in July and Derek wanted her to start work in August. I explained that Li would need either H-1B work authorization or optional practical training authorization to work legally. Li didn't have an H-1B visa and the H-1B lottery for that year had already concluded. Her only option was OPT, which required applying through her university's international student office and could take several weeks to process. Derek asked whether Li could start work while her OPT application was pending. I explained, no. She can only work after her OPT is approved and she receives her employment authorization document. If she works before receiving the EAD, that's unlawful employment. Derek responded, what if we just put her on as an unpaid intern until the authorization comes through? I explained, that doesn't solve the problem. Immigration work authorization requirements apply regardless of whether someone is paid. Unpaid work still counts as employment requiring authorization. Derek made a decision, bring her on as an intern. We'll call it educational training. By the time anyone asks questions, her authorization will probably be approved. On August 7, Li Wei started working at Novatech as an unpaid intern, while her OPT application was pending. Her OPT wasn't approved until August 28. For 21 days, Lee worked at Novatech without proper work authorization, and Derek had structured this as an internship specifically to circumvent immigration requirements. By September 2023, Novatech had at least 2 documented cases of unlawful employment, Raj working 10 days before his H-1B petition was filed, and Lee working 21 days before her OPT was approved. Both violations had occurred at Derek's explicit direction over my documented objections. I had detailed email evidence showing I'd warned Derek that these arrangements violated immigration law and that he'd ordered me to proceed anyway or had made hiring decisions that overrode my compliance recommendations. On September 12, 2023, Novatech received a notice of inspection from United States Citizenship and Immigration Services. USCIS was conducting a compliance audit of Novatech's I-9 employment eligibility verification procedures and H-1B visa sponsorship practices. The notice requested that Novatech provide all I-9 forms, H-1B petition files, labor condition applications, and payroll records for review within 30 days. USCIS site inspections can be triggered by various factors: random selection, complaints from employees, patterns identified in visa petition filings, or tips about potential violations. Regardless of the trigger, these inspections are comprehensive examinations of whether companies are complying with immigration and employment eligibility verification requirements. Derek called an emergency meeting on September 13 with me, Novatech's legal counsel, HR director, and our CEO, Richard Chen. Derek's tone was anxious. USCIS is auditing our immigration compliance. Priya, you handle all our visa stuff. Is there anything in our files that's going to be a problem? I responded carefully. Derek, there are at least 2 cases where employees began work before having proper authorization, and both cases occurred at your direction over my written objections. Raj Patel started work 10 days before we filed his H-1B transfer petition, and Li Wei worked for 3 weeks before her OPT was approved. Both situations constitute unlawful employment under immigration law. I documented my objections to both arrangements in emails to you. Derek's face went pale. You're saying we have violations in our files? Why didn't you tell me this was a serious problem? I pulled up my emails on the conference room screen. Derek, here's my email from June 15 stating explicitly that if Raj started work before we filed his H-1B petition, it would be unlawful employment. You responded that Raj starts Monday and to handle the paperwork afterwards. Here's my email from August 3 stating that Lee cannot work as an intern before her OPT is approved. You decided to bring her on anyway as educational training. Richard Chen, our CEO, looked at Derek. You ordered Priya to process hiring arrangements that she told you violated immigration law. Derek tried to deflect. I was trying to move quickly to bring on critical talent. Priya was being overly cautious about technical compliance issues. I didn't realize these were serious violations. Our legal counsel, Maria Rodriguez, was reviewing my emails. These aren't technical compliance issues, these are clear violations of immigration work authorization requirements. USCIS takes unlawful employment very seriously. Depending on how they view the violations, Novatech could face fines, enhanced monitoring, or debarment from sponsoring future H-1B workers. Derek, did you receive any other warnings from Priya about immigration violations? I provided additional documentation. Over the past 8 months, I've sent Derek approximately 15 emails warning about various immigration compliance issues. I've documented instances where he pressured me to expedite processes beyond what regulations allow, where he asked me to file petitions with inflated information, and where he dismissed my explanations of legal requirements as bureaucratic delays. Derek tried to defend himself. Immigration law is incredibly complex and slow. I was trying to help the company compete for talent in a tight market. Priya's communication style made it difficult to understand what was truly required versus what was just administrative preference. Maria looked at Derek sharply. Derek, Priya's emails are crystal clear. She didn't say, I prefer not to do this or, this might be a problem. She said explicitly, this violates immigration law, and, this is unlawful employment. Your response was to proceed anyway. That's not a communication problem, That's willful violation of federal regulations. Over the next 30 days, Novateca's legal team prepared for the USCIS inspection. We compiled all requested documents, identified the 2 unlawful employment violations, and developed a remediation plan. Maria advised that Novatec should proactively disclose the violations to USCIS rather than waiting for inspectors to discover them, and should demonstrate that the violations occurred despite the compliance manager's objections and that the company had now implemented additional oversight to prevent future violations. On October 18, 2023, USCIS investigators arrived at Novatec for the site inspection. They spent 3 days reviewing files, interviewing employees, and examining our immigration compliance procedures. The investigators identified the Raj Patel and Li Wei cases, reviewed my documentation showing I'd objected to both arrangements, and interviewed Derek about why he'd proceeded with hiring decisions over the compliance manager's objections. Derek's interview with investigators reportedly went poorly. He tried to argue that the violations were minor timing issues, that Raj and Lee were highly qualified workers who would have received work authorization eventually, and that Novatec shouldn't be penalized for trying to compete effectively for talent. The investigators explained that immigration law doesn't have exceptions for competitive business needs and that knowingly employing workers without authorization is a serious violation regardless of the worker's qualifications. On November 3, 2023, USCIS issued their findings. Novatec had committed 2 violations of immigration work authorization requirements, employing Raj Patel for 10 days without proper authorization and employing Li Wei for 21 days without proper authorization. Each violation carried a civil penalty of up to $16,000. Total penalties, $32,000. Additionally, Novatec was placed under enhanced monitoring, meaning all future H-1B petitions would receive additional scrutiny and the company would be subject to follow-up inspections to verify compliance improvements. But the financial penalties were just the beginning. Enhanced monitoring meant Novateca's visa petition approval times would be slower, making it harder to hire international talent competitively. The violations would be part of Novateca's public record, potentially affecting relationships with customers and partners who reviewed immigration compliance. And most significantly, Richard Chen and the board had lost confidence in Derek's judgment about regulatory compliance. On November 8, Richard called an emergency board meeting to discuss the USCIS findings and their implications for company leadership. The board reviewed the timeline. Derek had consistently pushed back against immigration requirements, had dismissed warnings from the compliance manager, had made personal attacks on Priya's communication style rather than listening to her expertise, and had directly ordered violations that resulted in federal penalties and enhanced monitoring. One board member asked Derek directly, "Why did you proceed with hiring decisions when your compliance manager explicitly warned you in writing that those decisions violated federal immigration law?" Derek responded, "Priya's explanations were confusing and her accent made it difficult to understand whether she was describing absolute legal requirements or just expressing administrative preferences. I was making business decisions to move quickly on talent acquisition." The board member responded, "I've read Priya's emails. They use clear language like violates immigration law, unlawful employment, and federal regulations. Those aren't confusing terms. And her accent has nothing to do with written email communication. It appears you dismissed her expertise and then blamed her communication style when your decisions resulted in violations." On November 15, 2023, the board terminated Derek Hamilton as VP of Engineering. The board concluded that Derek had demonstrated poor judgment in regulatory compliance, had created legal liability through willful violations, and had created a hostile work environment through discriminatory comments about Priya's accent. On November 20, Richard Chen called me into his office. "Priya, I've reviewed everything that happened over the past 8 months. You did everything right. You identified compliance issues, you documented warnings, you raised concerns clearly and repeatedly, and you were ignored and personally attacked for doing your job. You protected employees' immigration status, you protected the company from worse violations, and you maintained professional integrity despite pressure to compromise and personal disrespect. The board wants to recognize your judgment and expertise with expanded responsibilities." I was promoted to VP of Immigration and Global Workforce Compliance, reporting directly to the CEO. My salary increased from $96,000 to $155,000, a 61% increase. I was given authority to veto any hiring or employment decision that created unacceptable immigration compliance risk, and I was added to the executive leadership team to ensure immigration considerations were included in all workforce planning decisions. Over the next year, I rebuilt Novateca's immigration compliance program, implemented additional training for hiring managers about immigration requirements, and worked with USCIS to demonstrate our commitment to compliance. We passed our follow-up inspection in October 2024 with no violations found. In December 2024, I ran into Derek at a tech industry conference. He was working as an independent engineering consultant, trying to rebuild his career after being terminated from Novatech. He saw me and approached cautiously. "Priya, I heard you got promoted to VP after I left. That's quite a rise." I looked at him directly. "I got promoted because I understood immigration law and tried to prevent the violations you ordered. You got terminated because you dismissed my expertise, made discriminatory comments about my accent, and then blamed me when your decisions resulted in federal penalties." Derek started to respond, but I continued. "You said I needed to learn proper English to explain immigration requirements clearly. My emails to you were in perfect English warning that your decisions violated federal law. You said my accent made it difficult to understand what was required. I sent you written documentation that couldn't be misunderstood. The problem wasn't my communication, the problem was that you didn't want to hear that immigration law wouldn't bend to accommodate your hiring timeline. And when USCIS audited us, they didn't care about your business justifications or your opinions about my accent. They cared about whether we followed immigration law. We hadn't, because you ordered violations over my objections." Derek didn't have a good response. He walked away. Thanks for staying through this entire story. Everyone who's ever had their professional expertise dismissed through personal attacks on their accent, background, or communication style, only to be proven right when regulations enforce themselves. If this resonated with you, if you've experienced discrimination disguised as communication concerns, subscribe and share your story. These workplace tales remind us that expertise matters regardless of accent, that federal regulations don't care about executive frustration, and that people who blame communication problems for their own failure to listen learn expensive lessons when agencies arrive with penalty assessments and compliance violations.